right is Jackie Leone, Peter Coffin, my immediate right Larry Greenbaum, our vice chair. My far left is Chuck Hart, an alternate, and immediate left is Secretary Susan Ayer, and I'm your chairman, Ellie Alessio. First order of business, which would be to approve the minutes from January 9th. Have a motion?
Yeah, I'll move that we approve the minutes as written for January 9th.
Okay.
Second.
Second. And any errors and omissions or omissions? There is one. There is one in terms of Richard Johnson morphed into Ray Donald.
Oh,
That's what I said too. I didn't even notice that it myself, so we'll make that correction to the minutes. These were Susan's first official minutes, and they were really very well done and well detailed, so I thank her for that. Any other discussion corrections? All those in favor, please say aye.
Aye.
Opposed, say no. Abstentions? One?
Yes.
You weren't here. Okay,
Yes.
Jackie wasn't here. Okay, so we're all set there. We gotta wait 3 more minutes until 7:05, and then we can begin with the first hearing. I think there's a land use workshop conference coming up in May that I'm probably gonna go to at the end of the month, May 31st, I believe.
yeah,
I'm
there's
pretty sure there's a planning and zoning
a
conference.
conference up in Concord.
Concord,
yeah.
right.
Voting Center.
If anyone is interested in going, let me know.
It'd be good when they open that up for registrations, if you want to go, to get in early, because this is the year that we're likely to have the legislation passed. There's a bill up now that requires training for planning board and zoning board members, so there may be a big rush, and it always fills up anyway, so
They're gonna require that we have training?
some kind of training. It may be something as simple as downloading the materials and reading it. I don't know. They haven't worked out all the details yet, but
Well, that could get
that could get
interesting.
passed, yeah. It's jointly supported by the governor and both sides of the House, so,
okay.
and Senate, so. Likely. Plus, they're always good information.
Yeah, I don't go that often, but I always garner something. I like the webinars that they have. Participate.
Oh, yeah.
And you can here log in and do this, but you never know what legislation you're gonna pass. Thought Richard was, I wonder if he forgot. 'Cause I saw him at the polls.
Oh, it was only a few days ago, so.
I know.
Sounds like something I do.
I know. I did that with library trustees last week. We changed the night. We did it in the morning, so Monday night to Friday. Never made it to the calendar, never made it out of the house. I think we're at 7:05. The first hearing is OSP Realty from 52 Colby Road in Danville regarding property located at 62 Mill Road, Kingston, tax map R22, lot 26. This is a continuance of a public hearing that began on January 9th, 2020, whereby the applicant requests a variance and a special exception to the terms of Article 1044, Section J of the Town of Kingston zoning ordinance, and asks that said terms be waived to allow for third apartment in a two-family rural residential zone. Is the applicant here?
I have a conflict with the attorney, and I'm going to request one more continuance, please.
Okay, that will be your third one?
Second.
Second, okay. Usually, we have a practice of granting no more than 3, just wanted to let you know that, okay? But is there any objection to continuing this till the March 12th meeting?
Motion, so moved.
Okay?
I'll second that.
All right, great. All in favor, please say aye. You're all set, Mr. Pascal, for March 12th, okay? Okay, then we'll move on to the next hearing for Catherine and John Lawler, living at 12 Woodland Street, Amesbury, regarding property located at 44 Church Street, tax map R33, lot 3. This is a public hearing whereby the applicant seeks a variance to the terms of Article 103.2, Section 100 of the Town of Kingston zoning ordinance, and asks the terms be waived to permit use of the building formerly operated as Dagnall Sports for operation of an owner-operated machine shop, a non-permitted use in a single-family residential zone. Are the applicants here? Are you the Lawlers? Why don't you come on forward? Okay, now, you have not purchased the property yet?
No, we haven't yet.
Did you have permission from the owner to speak?
Yeah, we had that.
That was part of your application, okay? I just wanna, I thought I saw something, I just couldn't remember.
It's different.
Okay, great. The way this works, you tell us why you want to do what you're asking for a variance for. We'll open up to questions from the audience, both in favor and opposed, questions from the board, and if we're able to make a decision tonight, we'll try to do so. Okay, so state your case.
So basically, I went to a trade school. I went to Whittier Tech and learned machine trade and worked numerous shops, and then decided I could do it better. And 3 years ago, started my own, and I'm renting a spot in Haverhill. It's about 800 square feet, and sharing a space with my friend's shop, engineering company. But ideally, it would be beautiful for us to live in the house, and because of that property, it has a giant garage there. That would be perfect to bring my shop and all my tools there, and the commute would obviously be quite a bit better.
As opposed to paying a lease on a different space for the machine shop and then try and buy a house and have a mortgage as well. This would be a much more fiscally responsible decision for us, and hopefully we can work.
Okay. You haven't started any of the permitting or anything like that as yet?
No, so they just have it as a contingency of the sale that we would come here, and get a decision before. We didn't want to go the route of, even though in the listing of the house it says, oh, it's commercial, it was like, well, we didn't want to go the route of, trying to do it and then people, upsetting anybody because we didn't go the right avenue, so we wanted to make sure that we came to you guys first, and then we put that in the contingency with the sale and understanding that there is still a 30-day period if we were to be granted. We're taking that risk if we got the approval and went forward with the sale, that somebody could come to the board within 30 days, so.
Okay. Did you want to add anything this time? You'll have an opportunity to provide additional information should there be other questions, but are you all set to proceed?
Yeah, I think so. I don't know if everyone's familiar with what the machine shop is. It's just me and myself. My nephew works kind of part-time, but I have one CNC machining center, and I make like really complicated little robot parts out of aluminum and stainless. And so it's basically just me and my dog, and they're doing engineering on just the other side of the wall. So the noise is not, there's some noise, but it's not obnoxious at all. Not enough for office space on the other wall to be an issue.
Okay. All right, I'm going to open up to the audience. Is there anyone here that would like to speak in favor of the request? Is there anyone here that would like to speak in opposition to the variance request? Is there anyone that has any questions about the variance request? Mr. Bates, I know you're in a butter, that's why I was kind of, have a seat and pull up a microphone, how's that sound? Yeah, we won't let you play Richard Johnson tonight.
Kurt Page, 46 Church Street. I live right next door. How are you? My wife and I don't have any concerns. The only questions we ask is lighting and operation of business. Mr. Dagnall, who has owned that property since we've been there, has done an extraordinary job. We've been there for 30 years, not 30, close. So that's our only question, but we really don't have any any concerns, we just want to know the operation time, that's all.
Yeah, I mean, it's, I try to get up early, but not so early. You know, I work in Haverhill now, my shop's in Haverhill, so Hampshire to Haverhill, I'm there 7 to 8 in the morning, and usually out of there by 5. Occasionally there's weekends, but it wouldn't be, I don't think there, you know, your house is right behind, right? Or is it across?
We're right.
Oh, right now, oh, okay.
We're right next door, but you answered the question, you said it was just yourself.
Yeah, it's just
How many
myself, yeah.
employees, so we're,
You're good.
Yeah,
Okay.
tries to keep the visitors as infrequent as possible, because they usually try and come in and, you know, tell them how to machine and.
we're fine, we just want to know the operation.
Okay, thank you, Mr. Bates. Questions from the board?
You just mentioned engineering behind the wall. Is that where you are now, or do you have actually plans to have engineers?
No, I'm gonna split from them. I only have about 800 square feet a little corner of their shop that I'm sharing, like that, they had extra space, so I rent from them.
Okay, so that had nothing to do with the location we're talking?
No, not at all, no, that's just, that was an example more of the noise that I'm creating in that room. They're able to just completely have an office space and do engineering work on the other side of the wall.
So you'd be working in there, but you don't do any retail?
No retail, no.
So it'd just be deliveries of materials?
Yeah, and UPS, you know, no different than every other place. And I have one engineer that I make parts for that comes maybe once a month to either pick up or drop off parts or whatever, but it wouldn't be nowhere near what a retail would be as far as customers and traffic.
And the machine you described as like a milling?
Yeah, it's a milling machine, like I have a Bridgeport, I have a few machines, a lathe, and, but most of the one I use mainly is it's probably about as these two tables. It's all enclosed with doors, and it's, but based off of like a milling machine, so yeah, it's a vertical milling machine.
So it's basically, you're here because it'd be a change of use from technical sports, which to the building business.
Yeah.
That's not permitted in a single family residence.
So that it's not prohibited.
It's not prohibited, nor permitted, right? As with any young business, you're probably gonna grow. How many more what's the potential for you in that location in terms of number of machines and or people?
I don't want to grow. I worked in a place that had, 1,000 people, and I've worked in a place that had 6, and definitely neither of those is where I want to go. I'm really passionate about making things correct and right, and it's hard to find somebody that's a copy of myself. So it would probably only be a little bit, but maybe not even one more person. I think it's one more, I bet, would be the way it would go. And if I outgrew, then I would move to, a bigger place that's not there.
Yeah, I would say that assuming the building was to stay the same footprint, just based on machines that could fit in there and who could be operating them, going from 800 square feet to this potential building, there would be, in order for space for people to work, potential for one other full-time employee, but I would think that would be it. Just because the footprint of the machine takes up, a good amount of space in there, that there wouldn't really be an opportunity for more than like 2 people to be working comfortably in there. So, and we wouldn't be looking to expand the footprint of that building. So if that ever became the case, I would probably push him out of that building and tell him to lease an actual bigger place.
You wouldn't be the first machine shop to start as single-person operator in town and expanded accordingly and moved out because of the need for more space and so forth and so on. So I was just curious what your immediate plans were, actually. As representing the planning board, my question would be, does the planning board have strictures on the types of materials? I know in the machine shop you use different.
That would all be handled there for operation and things like that. You're not planning to work outside. This is mostly for people like Kurt,
He might be, you don't know
I
that.
don't know that.
I have
As long as they can't hear him, they probably.
Exactly.
Having 18-wheelers backing into your driveway, 3 o'clock in the morning.
Yeah, the noise, yeah, like he was saying, the noise is like, the interior wall that separates his current space from where the guys are doing the engineering work and answering phone calls and conferences and stuff like that is a very flimsy wall. And just to give you a sense of like the noise that actually, you can hear between them, it's the air compressor is probably the loudest thing. That's it, just the pump of the air compressor. The machine itself is just kind of like whoop, whoop. It just like makes a little whirling noise, so there's not really like any pneumatic, hammers or things like that are going on, so.
So it's a pneumatically powered machine?
Oh, it's
Yes.
electric, but there's the way that it changes to the next bit, that's pneumatic, and you have the air gun in it.
Not as far as materials and things like that.
Yeah, but
That's it.
normal permitting process, right?
By the state.
Any other questions?
Yes.
Mr. Greenbaum?
At the back end of the property, there's a tent building, for lack of a better
Oh,
phrase.
yeah.
What, are you gonna use that, or?
We haven't thought of using it because he has a tree. And then, that was the thought was, since that looks like it was from the RV that they had, is where they were keeping it. We were thinking like maybe we would put the trailer in there.
Yeah, not for the business though, that wouldn't be anything
Oh
for
yeah,
the
this is for
shop.
like an enclosed car trailer, just to store it in there.
Yeah.
Unless there was like an issue that is, if it's an eyesore or anything like that, but we were thinking,
It's existing, I don't, I was just wondering what you were gonna use it for, if you were gonna. use it.
yeah.
I'm not sure yet. I mean, it might fall down. My father had one that surprisingly lasted about 15 years. I couldn't imagine it was gonna last that long.
Well, that one looks like it's in pretty good shape. We unfortunately do not have a big giant RV to occupy that space. Not that point in our career, but we might use it to put a trailer in there, keep it out of the site.
All right.
That's it. Any other questions? Are you ready for the question? Do you have any other questions?
I don't think so.
Okay. So we'll have, this would be a variance. isn't it? Yeah, and give it to Chuck. We need one more. Oh, no, we got it, yeah. Okay, what we do is we have 5 criteria that we review. You'll hear us talk about it. And all 5 need to pass, and if they all pass, we grant you the variance with a 30-day waiting period, okay? And 2-year deadline.
Yes, yeah.
I'm gonna add something new we're gonna add. Okay, this is for, located at 44 Church, R33, Lot 3. So it's for machine shop and single family. Okay, after reviewing the petition after hearing all the evidence, by taking into consideration the personal knowledge of the property in question, the Kingston Board of Adjustment has determined the following. Number 1, will there be a diminution in value of surrounding properties as a result of granting this variance? Will the granting of this variance be of benefit to the public interest? Will literal enforcement of the zoning ordinance result in an unnecessary hardship? Will substantial justice be done if this variance is granted? And the 5th one is, will the use contemplated by the petitioner as a result of obtaining the variance be contrary to the spirit of the ordinance?
it's on that corner. The back, it's a pre-existing. Doesn't come up in the script.
Yeah. And see the prohibited.
It can go in lines.
Yeah, exactly.
That's why we're here.
Okay, we have the 5 criteria, and number 1. Okay, will there be diminution in value surrounding properties? All 5 voted no, so that passes. And number 2, will granting of this variance be of benefit to the public interest? All 5 said yes, so that also passes. Number 3, will literal enforcement result in unnecessary hardship? There were 4 yeses, 1 no, so that also passes. Number 4, will substantial justice be done? All 5 pass on that as well. And number 5, will the use contemplated will be contrary to the spirit of the ordinance? There were 4 no's and 1 yes, so that also passes. So all 5 criteria did pass. Do I have a motion?
I move that we grant a variance to the Article 103, Section 2, to allow the use of the former Dagnall's Sports Building as a machine shop.
Is there a second? Further discussion? All in favor, please say aye.
Aye.
Opposed, say no. All unanimously passed. Okay, you're good to go. Now, two things. You technically, officially, you have to wait 30 days in case someone wishes to provide additional information that might make us change our mind. And we've had some instances where variances have expired, and there is a 2-year window. So we're going to start making sure that applicants know going forward that you do have a 2-year window, but I'm sure you're not going to wait 2 years to pass on that.
Grant in there already in paper.
Hey, well, I'll say good luck to you and welcome to
Thank you so
Kingston.
much. Thank you.
Okay, item next, Mr. Khalil and Ms. DeMayo. Come on down. And we meet again. Still. Okay. This is regarding a 19-page road, Kingston, tax map R22, lot 32. This is a public hearing whereby the applicant requests an extension of a special exception that was granted on July 13, 2017, to the terms of Article 104, Section 4 of the Town of Kingston zoning ordinance to permit a 3-family dwelling in a 2-family rural residential zone. The special exception has expired per state statute. My colleagues and I were debating earlier whether or not it's a special exception or a variance, pretty much as we did at the last time we all met. And my view is that the issue is to allow a 3rd apartment in a 2-family residential. And under the current statutes of variance, it was not noticed that way, but I don't think it changes the intent of the notice or anything else. That's my opinion. Mike, I have a colleague to my right who disagrees and thinks it should be a variance, correct, Peter?
Well, unfortunately, it didn't get posted that way, but the only thing that got posted was your request for an extension of a special exception. And I agree that the intent was that you actually did apply for a variance correctly. And I think that was our mistake, that we just didn't include that. But I think that because they applied for the variance, we could hear that after hearing the first part, which is the request for extension.
It's one and the same. I'm gonna hear it as one is one. We can make sure that in the ruling, whatever the ruling may be, that it's clarified in the ruling. It's hard to have 2 separate hearings on this, Pete. It's one hearing.
Well, I think the first one,
first,
The first part, which is the extension of special exception.
okay.
We do have a legal opinion on that, and that is,
You obtained an opinion from the municipal,
New Hampshire Municipal Station, Stephen Buckley, Legal Services Council.
I can't hear him.
This is from the Legal Services Council of the New Hampshire Municipal Association. And says the period of time that a special exception is valid may only be extended by the ZBA before the expiration date and not after. If the ZBA could extend the validity period of a special exception at any time, this would render the 2-year time period meaningless. And then you brought up the issue of final approval. I had asked him what constituted final approval. Unfortunately, it's a state law that says that. The term
It's
final,
the state law that says what
the term
constitutes.
final approval means the same as that. That term is defined and described in RSA 676:3 and RSA 677:2. Quote, the date upon which the board voted to approve or disapprove the application, unquote. Assuming there's no aggrieved party and no motion for a rehearing and appeal to the Superior Court, the 2-year period of validity is counted from the date the board voted to approve the special exception. So that means that on July 13th, whenever 2019 expired. The example that I would compare it to is if you had a client that got a letter from the IRS because he failed to file his taxes, and it's now June, and they say that he's going to be paying a penalty for failure to do that. If you,
we're not going to get into debate. Please,
Well,
please,
no,
please
I mean-
wait for questions, please.
if he'd filed for an extension on or before April 15th, then he could have been granted. He doesn't even have to give reason, but.
Peter, you're going afield here.
No,
The issue,
but if you don't apply, I think you understand where I'm going.
we're beyond that point, Peter. We
Yeah,
are
it's expired.
beyond the
Okay,
extension.
so the answer is this board cannot grant an extension of a special exception. So as we described previously, and also when you,
Excuse me, has the board decided that already? Then why are we here? I mean, he's just said the board can't vote. Are we done?
That's his opinion. Please, I'm asking you to please restrain yourself a little bit. This is something the board has to work out.
He didn't
So just
say
sit
it
there.
was his opinion.
Please,
All right.
just wait.
it's both my opinion and the opinion of council. So,
Right, but that's the opinion you have not shared with the board. You didn't bring it up ahead of time. None of us are even aware what you did.
Can I ask a question?
Sure.
Isn't there a difference between what you're saying is a law versus an opinion?
Yes.
That's a huge difference to me. So if you're saying that whoever this is recited that it's actual law, then that has nothing to do with an opinion. A law is a law, that has nothing to do with an opinion.
yeah, and that's the term final approval, and that was what
I mean,
the
I don't.
council brought up before.
It's not a gray area to me.
It isn't. And so the other thing that the reason you brought this up was that we were under the impression when we last met that, because we didn't have a copy of the minutes of the November meeting in front of us, was that you had stated that it wasn't in the minutes that we had actually disallowed that. And in fact, after the meeting, we went back and looked at the minutes, and even though in the minutes of the January 9th meeting, we said we had recalled having a discussion of the expiration, but that you had said it wasn't reflected in the minutes.
No, I did not say that.
I think it did, because that's why we said that if it wasn't, that we agreed that it wasn't reflected in the minutes, that it was a mistake of our part, and that we would, and you also said we did not have no discussion on the video about that. I said I remember the motion, mention of it by the chairman. And so I went back and looked at the minutes, and Mrs. Alessio stated that the approval that had been granted has expired and an extension could not be granted. So that dealt with the original approval.
I did not,
I'm sorry, I'm gonna just, the minutes do reflect that it was the same.
I didn't say it wasn't in the minutes. He's saying I said something that I didn't say.
I don't wanna get in an argument here. Please, Mrs. DeMay, please, if you would just bear with me,
If you would
we
have
might make...
words in my mouth.
We might make you happy. You need to just calm down. This board needs to decide how we go forward. I don't care what happened before.
Okay.
I'm not interested in...
Excuse me, I'm looking at a new application for a variance,
Yes,
and,
I think that we could,
and we can act on that.
right.
Then that's what we're gonna do.
Okay, and the other application, I think we should vote to keep the attorney happy on on whether we can grant an extension on a special exception.
If we don't take any action,
I
it's,
think the action before us is to whether or not to grant the petitioner a variance to allow a third apartment, period.
No, and for a rehearing on the
Yes,
question of extension.
Okay.
That's what the application
Okay,
said.
if you want both, we'll give you both. You may not be happy with both, but that's okay. We're gonna give you both, okay? So we're gonna take up a variance for the third apartment on the two-family.
we take up the special exception first.
Sure we can.
And put that to bed.
Okay.
And then act
So
on
it
it.
wouldn't make any sense in a second.
Peter, no, you can't go to municipal social without the board knowing, number one, and without sharing the information ahead of time. That's all I'm asking, for future reference, okay?
Yes.
Because it would have been appropriate to share some of that, at least with you, so you didn't blindside. Maybe outside the door you did. Okay, I'm not gonna argue. All right, let's actually, all right, we did that.
Okay.
State your case.
I'd like to correct that I never said that the discussion on the extension was not in the minutes. What I did say and what you acted upon, Mr. Chairman, is that it wasn't in the decision. We read the decision, we agreed upon it wasn't in that, and that's why the motion for a rehearing was granted on that issue. It's also the variance because it was not stated in the decision. I would object to the board using the opinion from the municipal association in rendering their decision. They're not a member here, they don't have a vote, and they're not here. And we don't know what facts they base their opinion on, and it's not a court of law. As you know, we were originally granted a special exception under the ordinance 104, period 5J. And that was on July 13, 2017. And as you all are aware, the requirements to grant a special exception are very different from that of a variance, and the burden is much lighter. We've been here no less than 6 times with a site visit as well. At the time, the property was in pretty bad condition. It's been cleaned up. He's put in new windows. He did start doing some demolition when he learned he needed a building permit. He stopped. And now we're back here. Shortly afterward, he'd hired the engineer. As you all know, for those who weren't here, the engineer dragged his feet, didn't get before the planning board until September, at which time he was told that he needed to come back and get an extension. And that now a variance was needed. As far as when he came to that hearing to get the extension in November 2017, he did ask for an extension and a variance. The variance was denied. And the minutes indicate 4 out of the 5 criteria failed, but it didn't say which ones failed, which passed, so he had no basis to know what you based your decision on. It could be any of the 4. Also, the other thing that's concerning regarding that hearing was the building inspector likes to send the board memos. And he's done this a number of times, in fact, every time we've been before the board. And what he expresses in these memos is that the owner knew before he bought it and he shouldn't be able to make it legal now. And again, based on your minutes, we don't know how much weight you gave that building inspector's decision. But the case law has found numerous times in the state that an owner self-created hardship, whatever you want to call it, is not positive factor and should not be something considered by the board. So we don't know whether you considered the building inspector's memo in reaching your decision or not. So in today's decision, if, you know, when we get to that point, you know, we'd like it all out in the open. Also, the building inspector is not a voting member of this board, so I understand that the board takes opinions from various people, but it's not his decision, and it appears that every time he wrote a memo, and without the minutes letting me know, I don't know whether the board sided with him or not. But again, what the owner does, if it's a self-created hardship, oh, he knew when he bought it, doesn't matter, and it's not a factor to be considered. The courts have found that twice in most recent years, the most recent one being Hill versus Town of Chester, and they've sent the case back to the zoning board to reconsider it and to determine what factors they used. Also at that hearing, Mr. Khalil was told by a member of the board that, you know, if it's 1 or 2 months since it expired, that's one thing, but here we are 6 months later. Well, it's not 6 months later when he applied. The special exception was granted July 17th. You have to wait 30 days for the appeal period, so that brings us to August 17th. He went to the planning board the first week in September, and by the time, then he applied for the variance beginning of October. He wasn't heard to November. So it was really within 2 months that he took action as soon as he found out he knew. So if that really is a factor, that you're looking at the length of time, whether it be 2 months or 6 months, then you should consider it's much less than 6 months. And at the statute, 674-33 talks about 2 years from the date of final approval. And when an order is final has also been the subject of much litigation. And statutes are written as laws, but they're interpreted by the courts. This particular July 17th decision says the special exception is granted, but you will have to appear to the planning board for site plan review and obtain all permits. And you must wait 30 days. That takes it out of the final approval stage. That makes it conditional. So the order is not final until all of the conditions of the approval are met. And the conditions have not been met. So if you put in there, it's granted on the condition that he purchased the house. Well, if he never purchased the house, the special exception is never granted. So it's not a final order. And it's not a final order because there are conditions placed on the order, the approval. It's not a final approval because there are conditions. So one could argue that the 2 years doesn't start to run until he at least goes to the planning board. And the statute goes on further to say that in any event, no such special exceptions shall expire within 6 months after resolution of a planning board application. Hasn't been filed, well, he tried to file it, but it hasn't been filed yet. So that statute doesn't come into play yet. So the 2 years hasn't begun to run yet. So my argument would be that, you know, you extend it. First of all, you can't extend something until it's what we call ripe to be extended. So if he tries to get an extension prior to it expiring, there's nothing to extend because it hasn't expired yet. So it's not ripe. So my argument is that there's no final order, final approval yet because you haven't met the requirements of the statute, you haven't met the requirements of the order, and you can't ask for an extension after it's expired because there's nothing, I mean, before it's expired because there's nothing to extend.
So,
It's not your turn to talk, not your turn yet.
So, I mean,
Your presentation.
the fair and equitable thing to do here would be, let's just grant this extension and move on, and put all the conditions on it you want. You know, he has to be at the planning board by such and such a date. The project has to be finished by such and such a date, unless, you know, he comes back and asks for, you know, there's a bit of a problem somehow. But that would be the fair, equitable way. The other ways get into much more complex issues, which I would be happy to do first, or you can vote on that part first, whatever you want me to do.
I'll be voting on the special exception first. If you want to expand on the other piece of it now, you're welcome to do so.
Well, I have both ordinances, I don't know if you do. In the ordinance, I don't know if it was passed in 17 or 18, the ordinance that deleted the J, granting the special, allowing the special exception. Do you know what I'm talking about?
I know what you're talking about.
Okay.
I don't think it matters whether it's 17 or 18, but it's okay.
Well, what matters is it happened since the special exception was granted.
That's correct.
Okay, and that's what's significant as to whether or not that even applies, because you can't apply a law retroactively. So what you're essentially doing is you're taking the new statute, the new ordinance without the provision for a special exception and saying it applies to an application that was submitted prior to the enactment of that law, and that's blatantly unconstitutional. And I can talk about that more later, but I think that what's interesting about your change in the ordinance is you took out 1045J, which allows for a special exception and tells you what standards you have to meet, which I've stated, and I think you agree, that they're much less stringent than a variance standard. But when you amended the statute subsequent to the application, you did a couple things. In 1045C, which talks about structure dwelling regulations, and it talks about commercial building, but you said it shall not exceed X number of feet, except by special exception as noted below. Did you forget to put it back in? It's in the ordinance, so there's something right there, something's wrong with the ordinance, because it says there's a special exception as noted below, and there's no special exception there. And that's in your amended one that was passed in 18 or 19. Of more significance, though, is if you look at 1044J, the ordinance says permitted uses, J, single family and/or two dwellings, paren, two family homes, comma, accessory apartments, paren, comma, and incidental uses. The ordinance is amended, says something very different. It says permitted uses, single family and/or two dwellings, paren, two family homes, accessory dwelling units, which we know are separate ordinance altogether, apartments. It's a permitted use by your own ordinance, and incidental uses. In the case of accessory dwelling units, the standards found in Article 206 apply. Doesn't say how many apartments, doesn't say whether you can have 2, 3, 5, 10, 15. It's a permitted use under your ordinance. So our argument is we don't need anything but a building permit. I don't know how you want to resolve that.
That's your opinion.
Well, it says it right here. My opinion, this is what it says. Apartments are permitted uses.
Yeah,
So-
and in rural residential, two-family units, two-family apartments are permitted.
It doesn't say two-family, it says two-family, it says two-family homes, comma, accessory dwelling units, comma, apartments. It specifies single-family, it specifies two-family.
Okay.
It doesn't specify how many apartments.
Okay, thank you.
So our first position is, we don't need anything because apartment is a permitted use. Secondly, if you do feel we need anything, it just makes more sense to grant an extension. Otherwise, we're gonna be going around this for a long time. Next, if you want, you can vote on those two issues, or I can go into the variance. They're all on the alternative.
Thank you. Comments from the board?
You said there was conditions on the SE, on the special exception? Did you say there were conditions on these?
On your approval, yes.
What were the conditions listed? So we should say with the following conditions. What conditions?
Planning board approval, building permits.
Can you read the,
You want me to read it?
yes, please.
Okay, at the July 13, 2017 meeting of the Board of Adjustment of the Town of Kingston, the board voted to grant a special exception to Article 104, period 4J, under the criteria of Article 104.5J, allowing a 3-apartment structure at 19 Page Road. The request for a special exception to Article 206.2 was withdrawn by the applicant prior to a vote. You will have to appear before the planning board for a site plan review and obtain all permits from the building inspector. In order to allow any interested party an opportunity to challenge this decision, you must wait 30 days from the granting of the variance to begin construction.
So, where does it say conditions?
Conditions are you have
Where
to...
does it say conditions? Can you read that word, conditions?
No, I can't read the word
Okay.
conditions.
So the point being is that those are requirements. You said you were required to fulfill the planning board. This is informative to the applicant of what he should do next. You always have to get a building permit. You always have to go to the planning board if you're going to be doing something commercial.
Wasn't commercial.
So this is not a condition of the variance. This is just letting you know what the town regulations are, what the person has to do next. Therefore, there were no condition. Condition is, if it was a special exception, conditioned upon, and we, I don't know, made some kind of condition, like, only, low-income people could rent. I don't know, that's a kind of silly one, but, we would state a condition as a condition.
I understand you disagree with my
Okay.
position.
All right, so the point is, there were no conditions, therefore, the final approval, as per state law, is on the date the decision was granted. Because it wasn't a condition. So therefore, that's when the shot clock started. And I do remember telling Mr. Khalil that before he left, that, you know, reminding him, yeah, you have to go to the planning board, remember, he said, oh yeah, I'll be there in a month. And I thought that was a little optimistic, he was enthusiastic, so good on. It wasn't until after some issues involved about doing work without permits that this whole reminder that he needed to go to the planning board came up.
And where does that fit into the argument? Where's that in the thought process? What does that have to do with
Well,
it?
it's because at some point he decided that he was going to do the work without meeting.
You don't know what he decided, and you weren't in his mind.
So anyway, he started, let me put it, he didn't decide. He started to do the work. He was interrupted by the town.
Okay, so we'll put a black mark here. Okay, one black mark for Bob.
But the thing is that there was no condition on that approval. So that kind of negates it.
We need to move on from that.
Okay.
Okay?
All right, I think we established that.
Okay.
May I
Have the floor?
interject?
Yes.
Number one, I don't agree with all of what you said as being the end-all and be-all. And I'm not sure that I agree with everything Peter said. However, if it is not legal or not permitted to give an extension to a special exception, if it is, on that premise, would you have any objection to our just reviewing the new application for a variance and let us act on that?
Absolutely not, Mr. Greenbaum. I will do whatever this board wants us to present, so you can vote on any or all of the above. If that was your question, I believe.
If we, then to the board, if you take what Peter said as being factual, now that's an if, and we cannot extend a special exception, get the words right, then deny it or not act on it, because it's
That's why I
a
said
moot
we need to
issue.
move on. I do agree with
I think
Peter.
in fairness to them, we need to act, because they made the application, I think we need to vote on it.
Well,
The question that Mr. Greenbaum raised was, do we believe the extension, special exception can be extended? I do not. Not only did you say that, but and through the municipal association, and I had talked with Peter Lawson, our town council, he also says they cannot. That is my opinion clearly, that we cannot extend a special exception. I think we should move on, deny the special exception, and move on and deal with the variance.
Deny the extension.
The extension of the special exception,
Yeah, got it.
because it was granted 2.5 years ago. Regardless of the, and Ms. DeMayo made some excellent points about why she feels it still merits it. So the variance may be more stringent than the special exception was if and when we grant that.
And thank you,
So-
we did make mistakes when we.
So, Peter, please, I don't want you to go there. I want you to stay right here with me. Leave Ms. DeMayo alone.
I'm just speaking as a planning board. Clean that up.
You're not on the planning board tonight. We can yell at you for designing some of these
I know.
regulations, because we have nothing to do with them, but that's a whole nother night. So is there any more discussion on the special exception?
No, I
don't know if
just-
the audience wants to weigh in on that at all back there.
I did want to say, I actually understand exactly what you were saying, and I agree with you. I
Okay.
think that's the best thing to do for everybody.
then what we should do, in my opinion, is we should move to deny the extension of the
Special
special
exception.
exception. And I will so move.
Is there a second?
I'll second.
Everybody second, beautiful thing. Discussion on the motion. All in favor of denying the extension of the special exception granted in 2017, please say aye.
Aye.
And ayes have it. It was a unanimous vote. So the extension of the special exception has been denied. And what we will now take up is the granting of a variance to allow a third apartment in a two-family rural residential zone.
That allows apartments under your ordinance. You have to address that. I mean, it's there.
We are addressing a third apartment in a two-unit building.
We can't address this, just because the parentheses were left out, and she read that. So it says, J, single family and/or two dwellings. And then it says parentheses, two-family homes, accessory dwelling units, apartments, and parentheses. So it's either single family or two dwelling homes. So it's two
So
dwellings.
it's two dwellings.
So
It's
either one-
subject to interpretation.
it is subject to interpretation. However, the parentheses lists the types of dwellings, two-family homes, ADUs, or apartments.
I think we're not going to be able.
That's your opinion.
Right.
She has a different, I have a third one.
So,
Okay,
and if we got. You sit still for a bit. If we had fewer attorneys in here, we'd have a few more opinions as
That's
well.
right.
So that's
And I'm not an attorney.
So the point before us now is whether or not we should grant a variance. Now, Ms. DeMay has an opportunity to present her case as to why we should grant a variance for a third apartment. And you can disagree with whether it's an apartment or not. To me, it's an apartment. It's not owner occupied. There are two apartments, legal apartments in there now. We want to have a third one, which would make it non-conforming. You have the floor.
Well, I have to go back to the fact that right, there's 3 apartments in there right now, not 2. The There's 3.
and one's demo. So there's 4 units, and there's 3 in there being occupied.
3 are being occupied now?
That wasn't the case in December.
That wasn't what we were told originally.
You told us there was 2.
You were told us there were 2 apartments.
It's been a 4-family.
Well,
That was way back when.
it was an illegal 4-apartment unit when you purchased it. And when you came for us to the special exception, you compromised in the process, because it was going for several months. We had sidewalks, tried to work with you, you definitely tried to work with us as well. And so the compromise was to put a 3rd apartment in that building, not a 4th. And that's what you got a special exception for. So now, as far as we're concerned, we're going to discuss.
Exception was never exercised.
Correct. And we have,
You know what, do we really need to go there? I mean, he's been in the process of renovating, so,
he told us in November, December that there were the 2 in there. And we said, why should we make a conforming property non-conforming? But we went forward with it because of your request for, you told, I definitely, you said,
It would be in the minutes, wouldn't it?
it might be. I don't have the minutes with me.
what minutes? I have them. Minutes in November?
Well, that was the first time you came before us, is that correct?
Since
Mr.
me?
Khalil, Mr. Khalil, was that the first meeting this fall? I'm talking about what happened, November was the first one you came back to us
Oh,
for?
I'm confused, we've been here 9 times.
You were here 9 times, not because we made you come
I
back.
don't know when I've been here, Tricia has everything written
I'm
down.
just talking about since November, when you wanted an extension for the special exception.
What month it was?
November, it was November.
November, wasn't it? So it should be the,
I don't remember.
it's not 9 times since November. November 14th. Don't know if it's in the minutes.
Minutes reflect that Ms. Alessio stated the approval had been, when Ms. Alessio stated Mr. Khalil was now in compliance with only 2 apartments. Doesn't say who said there were 2. That's what the minutes reflect.
Ms. Alessio, oh, should have been Mrs., that's right, stated Mr. Khalil is now in compliance with only 2 apartments. She stated the approval that had been granted has expired and an extension could not be granted. So in November, you had 2 apartments, and that was conforming. That was the law allowed you to do that without any discussion.
You stated he had 2 apartments in November.
He did.
He did, I'm sorry, you weren't here.
It's a 4-family, one's got it, so there's 3 left.
I think you just talked yourself out of a legal apartment in there.
Well, my plan was there was 4, let me just go, there was 4 units in there, and one was a very small one. I was gonna eliminate the small one and make 3 luxurious apartments, but I haven't done anything, except I went upstairs and one of the apartments was so smelly and everything, I just took the sheetrock out and just, it was gross. So I ripped the floors out, the rugs and the appliances, and I threw them all in a dumpster. And that unit that's actually huge and beautiful is vacant, and the tiny little one and the 2 other ones are being occupied. But that wasn't my plan. But the tiny one I was just gonna completely eliminate and use it for storage.
Right.
That's a new story.
Well, he did say he was gonna get rid of that one. I'm pretty sure he had said that you were gonna get rid of the 4th one, but you did. So really, what you're here was to make the 3rd one a legal apartment. It's still not illegal
Well, I don't want it. I want to do it legal. That's why I'm here.
for a 3rd apartment, that's correct.
Yes. Yes.
Okay. On the issue of the variance, I'm going to go back to the fact that this is a new ordinance that you're applying retroactively. And RSA 674-19 states that a zoning ordinance adopted pursuant to this statute shall not apply to existing structures or existing uses of any building.
Why are you afraid of a variance?
I'm not afraid of a variance, I'm just...
Yes, you are.
I'm not afraid of variance, I think that you're increasing the burden when you can't take a law that's enacted and apply it
Mr.
retroactively.
Mayor, this board does not, believes that you had a 2-year window to act on the special exception. And you came to us after the special exception had expired to get relief to move forward and to pick up where you'd left off. We're saying you don't have a special exception. We're willing to look at a variance to allow making that third apartment legal, and you keep talking yourself right out of one.
Well, I hope I'm not talking myself
Yes, you
right
are,
out of it by looking at your own ordinance.
Well,
But
Any non-conforming use in existence prior to the enactment of a new ordinance, the new ordinance doesn't
can you read
apply.
between my lines?
Yes, I can, but,
You're not doing so.
all right, variance. I just want to preserve my points.
You can always preserve your points. You can sue us for anything at any time you want.
but we're
That
starting
is
to
the
know.
American way.
So we're starting to know, so.
We are
as of
starting to,
February.
and I said that.
Starting to what?
De novo.
Brand new.
I understand that and I disagree with that. As long as my point's made, I'll go on with the variance.
Thank you.
Okay. Variance will not be, obviously there are 5 criteria for a variance.
Yes.
Pursuant to the statute. And the first one is variance will not be contrary to the public interest. And the best way to look at that is to look at the purpose of the ordinance under rural residential. And the purpose, and this is interesting in this district, the district is primarily intended for business, professional offices, and residential use. But then it goes on to really limit the size, scale, and expansion of neighborhood commercial uses. So it's really, the purpose of this ordinance is, it's residential, but let's really look at the commercial and limit it so it doesn't change the effect of the residential. That's how I see the purpose. So the fact that residences are clearly allowed, this is a residence, whether it's 1, 2, or 12 families, it's a residence. People live there, it's not commercial. So the variance will not be contrary to the public interest because the public is always interested in affordable housing. Again, we're back to what the spirit of the ordinance. Generally, as I'm sure you're aware, zoning's been litigated forever, and it's generally been held that if the granting of a variance will not injure the rights of others and is not contrary to the public interest, then it's within the spirit of the ordinance. And making this building 3-family will not injure the rights of others, as it will add some affordable housing to Kingston. It's already been there, and it's not contrary to public interest because the interest always has an interest in housing, and it's residential in a residential and commercial district, so it's the lesser of the uses. Substantial justice is done. Again, look to the purpose of the statute, the purpose of the ordinance, and it's primarily intended for business, professional, and residential use. Again, the rest of the purpose clause talks about limiting commercial use. So substantial justice is also been found to be done if any loss to an individual is not outweighed by the public interest. And the board is, obviously you have to do the balancing test as the courts do. But what the courts have said in this area of law, in much of the area of zoning, is that the constitutional rights of a landowner to own property must be respected and protected for reasonable zoning restrictions. And the courts have stated this over and over again. And again, I want to go back to the building inspector's continued opinion that it's the homeowners or the owner's own self-created problem, it's not a factor that should be considered in your decision. So the values of surrounding properties are not diminished since the original granting of the 3 units by special exception 2 years ago. There's been no diminution in property value. One side of the property has a fairly old mobile home on it, and the other side, the other abutter, is essentially a commercial use. It's a residential home with a huge concrete business on it. So there's been no decrease in the value of the properties. If anything, Mr. Khalil improving the appearance of this property would only enhance the neighborhood. And the last one, literal enforcement of the ordinance would result in an unnecessary hardship. The big one, I guess we can call it, that's been litigated for years, and it's gone through a number of evolutions, which I think are important, because you see where we've been and where we've been, where we got to, and now where we're going. And it used to be the old days that that one of the first cases that found hardship was unnecessary was it found that the proposed use caused no injury to public rights, was not contrary to public interest or private rights, and there was no diminution in surrounding property values, and the hardship was unnecessary. The hardship was unnecessary. The court, the next line of cases went on to say that the zoning board's actions cannot be arbitrary, confiscatory, or duly oppressive because of the condition of the property. That when you look at a restriction, this was more applied to a use restriction, not a dimensional restriction, that it has to be a reasonable use. You can't just arbitrarily decide that there was no hardship. You have to really look at everything. And they went on and on. And then they said, well, in order for a hardship to exist, the owner can't make any use out of their land. Well, that one didn't last long.
Speed it up a little bit, okay? Because we're very well versed in hardship.
Okay, so then we know that what you really have to look at with hardship is the constitutional grounds. You have to determine if the zoning restriction as applied to this particular owner's property interferes with reasonable use of the property, considering the unique setting of the property and its environment. It's a residential area. It's a reasonable use. Whether we like it or not, it's been there for years. And three apartments in one building is a reasonable use in a residential area that allows, at a minimum, allows single family as well as 2-family, and I would argue apartments. Although I understand the board doesn't agree with that interpretation of the statute. The other significant thing is there has to be a fair and substantial relationship between the restriction itself and the purpose of the ordinance. So the purpose of the ordinance is to maintain the neighborhood, to maintain in this particular area, you've got commercial, a residential, and a mobile home. So you've got sort of a mixed use. So what would the relationship be between restricting this to 2 units versus 3 units? There really isn't any. And if you go back to the purpose of the ordinance under your preamble, the purpose is to lessen congestion, which obviously, if you add another person, there's more congestion, but not significant. Secure safety from fire, panic, and other dangers, to promote health and general welfare, to provide adequate light and air, to prevent overcrowding, to facilitate adequate provision of water, sewage, schools. Clearly, restriction from a 3-family to a 2-family has no fair relation to that. And a variance would not injure the public or private rights of others. Nobody's being injured by this. In fact, the neighbors are being benefited by the enhancement in the property. So our argument is that there's no fair and substantial relationship between the ordinance and the restriction. It's a reasonable use, and it would not injure any public or private rights.
Anything new to add?
And that's it. Is that concise enough at the end?
No.
Come on.
I know the truth, no. You could have shortened it up a little bit. That's all right. You have every right to talk.
Okay, thank you.
All right, questions from the board?
Yeah, you are familiar with RSA 674-33?
I am?
Yeah. And I noticed that you omitted that little history.
What history?
A little history about this, sorry.
You're gonna listen a minute.
I know, but if I don't understand the question.
No, it's for the history of the hardship, because that's the one that you said is kind of the crux of this. The law established that in 2009, decided they needed, because of all these court cases, Simplex and Boccia and Guilford and you name it, they decided that we, ZBAs and planning boards, needed some guidance. So they said, for the purposes of this paragraph, this is under literal enforcement would result in unnecessary hardship. This is number 5.
I don't know where you're reading, I'm sorry.
Okay, number 5 in your list of criteria, literal enforcement of provisions of the ordinance would result in an unnecessary hardship. I'm reading straight from the RSA 674-33. 1B5A. For the purposes of this subparagraph, unnecessary hardship means that owing to special conditions of the property that distinguish it from other properties in the area, no fair and substantial relationship exists. I now won't reread the stuff you already read, but the proposed use of the reasonable one will be if it can't meet subparagraph A. It says that hardship will be determined to exist if and only if, again, owing to special conditions of the property that distinguish it from other properties in the area, the property can't be reasonably used. And you talked about that without, can't be reasonably used for its intended purpose without getting hurt. So the question I have, in order to make your case, is what are the special condition of the property, what special conditions of that particular property that distinguish it from other properties in the area?
The abutting property is a commercial use property. It's a resident with a commercial use attached to it, a substantial commercial use, by the way. And on the other abutter is a single mobile home, so that distinguishes it. And case law has
distinguishes what? The property. What's different about 19-Page Road that makes it a hardship to allow a third apartment? That's the question.
No, the question is what distinguishes it. As I understood the question is...
distinguishes from other properties
in the area.
Which is a rural residential area, so there's properties, yeah.
One of the properties in the area is commercial.
And another one is
although not
residential, and then there's across the road is residential, single-family residential, across the other side of the road is vacant, and then the street is a state shed.
There's a state shed across the street.
Well, yeah, that's right.
I was just talking about abutters, but there's a state shed. It's on the major highway that goes through Kingston. It's not on a rural road. It's on 111. It's not on, one of these side roads. It's, and it, as I said, the properties around it distinguish it because it's the only 2 to 3 family residential in the area.
So it's not true. It's right now it's a class F family, so that would be.
That's my answer, but I also want to stress that since that law was enacted, the law of zoning and hardship keeps evolving, and more cases have come down since 2009. that continue to evolve the definition of hardship. If you'd like, I can go through them all, but
Well, anything that's, for the Supreme Court is overridden,
I'm sorry?
as the Supreme Court overridden, or made null and void?
We're not going to debate law here, that's not the point here.
Okay.
It interprets the law.
Okay, so,
Right.
That's my answer.
so the question about special condition, what's special about that property in a rural residential area? That not what's special about the abutting properties, but what's special about your property? Or-
I don't think you can call it a rural residential area when it allows commercial uses. You can call it the rural residential
You
district.
know, it is zoned that way, that is the zone, there are things that are grandfathered in, there. You know that as well as I do.
No, I agree. I didn't say.
But we're asking-
Rural residential area. It's the zoning district.
It's zoned rural residential, and rural residential allows two-family, it allows mixed use, it allows commercial.
Correct.
All that is in there. So, in order to meet the fifth criteria on hardship, the question before you is, what is unique about your property that we should allow a third apartment? What is unique about that property on 19-Page
It's
Road?
the only multi-family dwelling in the area. It has been, it's a
Area you define
two-family.
the corner, you define Mill Road,
That, abutters.
your butters.
The abutters, okay? Define it as the abutters. I define the area as one of a major highway, major state highway, which makes the property different from other properties.
So you're saying, I want to be specific, you're saying to us that the reason the 19-Page Road should have a third apartment is because the other abutters do not have 3 apartments on it.
No, I've gone through the 5 criteria.
I'm asking about I'm not, I have no
Large
problem.
argument again, I will.
No, I don't want to hear all the nuances. I want to know specifically. That's the crux of this issue. It is the crux, is whether or not there's hardship attached to that property. Because if it would create hardship for Mr. Khalil to put a third one in, you need to tell us why. Not the laws, we know it's allowed, we know that 2 apartments are allowed, we know there's commercial behind it, we know.
Well, then I don't know what you want me to say. I've said it's unique property, it's the only multifamily dwelling, it's on a state road, it's, I don't know what other 2 or 3 families are next to a commercial use and a mobile home. It's got the appropriate amount of land, it's on a corner, it's different from the state shed across the street, it's different from the house down the street. I don't know what you want me to say. I've told you all the requirements of a hardship. If you don't agree with me, that's your choice and that's your position. I don't know how to explain it any more than how I've already explained it.
There are a number of two-family houses in that general area.
There isn't one next door, there isn't one next door to that, and there isn't one next door to that. There's not one over there, there's,
I beg to differ.
If you go down the road a little
I
bit.
believe
yeah, down the road, but
one, a couple of houses up from him. I don't know what number it is, but coming back towards the school, there's
There's several.
1 or 2 right in that area. Big houses, two-family.
I don't know what area you're encompassing.
Right.
Is it-
It's just down the street.
Just down-
You're limited to your butters only, and we're not, because we're looking at the zone. That's our job to do that, not just who the immediate
The
neighbors
zone is just
are.
about all over the town. Rural residential,
Well, there's several zones in town,
but rural residential is the largest, as
maybe.
yeah. Okay.
Mr. Guido,
Somebody else want to say something?
Mr. Hart.
Well, I don't have any questions. I have an observation and an opinion. I'm inclined at the moment, with all the conversations going back between your opinion, Peter's opinion, the law, all that. I'm not a lawyer. I understand some. I don't understand some. At the moment, I would be inclined to deny the variance so that Mr. Colel can take the zoning board to court so that a judge can decide whether the information is correct or not, because it's a simple function. It's a variance is what you want. But it's far too much information for me to comprehend. I would rather have the judge tell me and come back to us and say, okay, this is what you gotta do or not do.
You know what,
And then Mr. Colel can take us to court, spend the money to go to court, and
that's fine,
and he's gotta vacate the third apartment. If he wants to go all through that's what that's his choice, but that's just my opinion.
observation too.
Would you let him finish, please?
I'm sorry.
That's just my opinion right at the moment with all this conversation going. Somebody wiser than I, other than from a straight variance, has got to make some decisions.
I have two observations. The purpose of the zoning board, and I've said on many town boards, is not to make your citizens' lives miserable, but to sort of assist them and help improve your town to needs that you need or you don't need. You know, putting in, I mean, the big one that comes to mind when somebody wants to put in a sexually explicit store, everybody goes up in arms. I happened to be here for the previous hearing. I didn't hear the word hardship mentioned once by that applicant. I didn't hear the board discuss not one of the 5 variances. So why is this hearing so different from that hearing where we requested?
Excuse me, you didn't hear that discussion? We had that discussion.
I didn't hear the word hardship until the chairperson was checking off the things. I didn't hear those discussions, so I guess I wasn't listening. But I think you need to, you know, just an observation.
I haven't spoken.
Can you speak? I think it's time for you to speak up.
Well, I mean, we went back and forth the first time, and all I'm doing is improving the property. It looks absolutely gorgeous, and I'm about to do vinyl siding on it, but I'm up in the air with anything right now because I'm having a hard time here. But I mean, I was so excited, and I have the vinyl siding picked out and everything, and it was already approved once. I mean, how did you guys make the first decision? I mean, Mr. Peters, Peter Coffin, he's so against it, but how did it pass the first time? I mean, I don't understand it. I'm just trying to better the place. It looked like a complete junk hole over there. I took so much garbage out of there, and the place is looking beautiful, and I'm going to continue to make it look beautiful. And I don't want to have to go to Superior Court. And I'm not. If you go there, we're going to turn it into a 4-family. And the facts that I stated before is, for 25 years, that's been a 4-family, and there has never been one cease and desist, get out of that building in the file for 25 years.
It hasn't been a case since you purchased it.
No, before.
Sorry,
Okay, hold
I
on a
disagree on that one, because there was a cease and desist from all town officials to go on that property issued by Mr. Crosby.
Okay, there was a letter from a lawyer saying, leave us alone. Leave us alone. Am I going to be okay for 20 years? Because I could do that too.
No idea what happened.
No, but anyway,
but that's why I say, the town was not allowed to go and inspect. Mr. Crosby definitely had a lawyer's letter sent to the town, and they couldn't go. It was only when you invited us to come to the property, because you had permission from Mr. Crosby, that we got a chance to see what was in the building. And there is no question that you have since made substantial improvements.
Thank you. Also, at the first, when I represented John Crosby, it's because I had a purchase and sales agreement with him for a certain dollar value, and it was subject to a 3-family dwelling.
Subject to a 4-family.
No, it was subject to this approval of being a 3-family. It was subject to a 3-family approval. Once I got the approval, then I purchased the property because I met everything was correct. All my loans and everything, they think it's a 3-family over there, and I thought it wasn't. I did everything I could to turn it into a 3-family as fast as I could, like I said. But it's just the engineer dragged his feet, and Larry Greenham, he was the one that quoted when I was here by myself, when I thought it was going to be a piece of cake. He was the one that said, you know, if you were only late by a couple months, it wouldn't have been a big deal. We might have might have approved it, but it's 6 months. But then when I went back and said, Tricia, I am having a problem. I can't believe they approved it, and now that we're going through this all over again. She started doing the math, and she said, it was only a couple months. So even Larry saying, if it was only a couple months, we might approve it. So, I mean, I'm only trying to better the town.
I'll let Larry speak for himself.
There was so much crap. That place, I wish I had, you
You
guys.
know, the one thing I haven't heard from you is what you're just saying now. You put a lot into it. You can claim hardship because there was uniqueness to that property. And you have not said that until almost now, because I'm almost putting words in your mouth.
Thank you. I have, I mean, I appreciate it, Electra. The tenants have built a beautiful rock garden out front, and I thinking about even putting a water fountain in the front and the
But Mr. Khalil, even if you convince this board to grant the variance, you still will have a 2-year window. You're not years ago.
If you could see the check I wrote to the engineer as an $1,800 deposit, it was.
Got a different one.
No, it was way before it was way before the extension, but he dragged his feet to Lavelle. I did everything I said I was supposed to do. And while I was waiting for the engineer to do his work, I was cleaning the outside, making it beautiful. So, I mean, there's a lot of hardship there. So, I mean, this is never gonna end.
It conceivably could not end except in court.
Yeah, well, I don't know, it doesn't need to go there because you already approved it and you already had a good heart and a soul and I was very sincere like I am now. And I'm just bettering the town of Kingston. I don't want to fight with the town of Kingston. I don't want the house to continue to look like that. And, you know, I want it to be attractive. I just want to move forward. I already have an approval. Now, I'm not the smartest guy in the world, but if you go to court and you do this all over again and the judge says, well, you already gave him approval, I mean, I'm thinking like, it's like a no-brainer.
But that's where we would come in to say we have a 2-year window. That's by state statute. It's not New York. It's not Kingston.
And we are going from a 4 for 20 years. And before I bought it, I did review the file. There was nothing in there as far as a cease and desist. And every four units on that building with by the fire department, the building department, people, the ambulance showed up a couple times. They're referred to as unit A, B, C, and D.
Yeah, but that doesn't make it illegal. That does not make it legal.
But at the same time,
because the fire department's gonna come and save lives. Whether you have 1 illegal apartment and 3 illegals, it doesn't matter to them. So that's not a fair thing.
also, fuel.
There is a new sheriff in town. It's not, the old laws are gone.
Okay. Also, there's documentation of the
humanitarian aid. Just because they help someone keep warm or give them food and clothing does not make their apartment legal. They're two different things.
I understand. What happens?
No, what he doesn't, if I just may.
Let me just say one more thing.
Okay.
What has changed? The only thing that's changed since the last approval you gave me was I spent $60,000 on the property outside cleaning the lot and getting the property building inspector, and I'm continuing to do that. Nothing has changed, so why wouldn't you just grant me a simple extension so I can finish it?
Extension doesn't work for us. And I told you that.
Did something go wrong in between the last approval that you sold this now? I mean, I'm not saying you sold it.
You insisted on a special extension of a special extension.
But forget all the legality stuff. You guys are real, just normal, everyday people, nice people. And what has really changed? Nothing has changed. You gave me the approval, now you don't want to give it to me. I don't understand it. I'm from Atkinson, everybody loves each other in Atkinson.
No, they fight like this still.
I mean, you go there, and people, there's never a problem. I'm just trying to better the place and move on. It's a huge place, and I've been making it nice, and I just want an extension so I can finish.
Okay, enough.
Okay.
Anyone else?
I'd like to answer her
Go ahead, all right.
question from earlier about the the criteria, I think you know this, that I made a point of saying.
Talk about a hardship on me, I mean.
No, seriously, the value of the surrounding properties are not diminished. This is the one that we voted in your favor the last fall when you came in, and we congratulated you on that. And that was to answer the question of which of the criteria, which of the 4 failed and which one passed. And so number 4 passed, and the other ones were all voted not to pass by.
And for Ms. DeMayo's enlightenment, all those votes are in the file folder, and the zoning board has its own cabinet downstairs. You can go to the selectman's office anytime and see those. It's public information.
I have been to the office 2, 3, 4 times and asked for the file. I've never received those.
I don't know who you asked, because this is one of the 2 people you would have asked, so there you go.
Did you ask for the ZBA file or the property file?
It's not in the property folder.
Yeah, if you asked.
I've been to both offices, the first one and the selectman's office. But anyway, I've never seen it.
Obviously, there are 2 files. There's the property folder in the selectman's office, and also in the selectman's office is the zoning board. I keep a file in every case we hear. This is the one from 2017.
Yeah.
I have a question.
Sure, Jackie.
How do we move this along?
If you just say it's time to move the question.
I really do. I mean, there's been enough conversation, opinions. I think everybody, I can't speak for anybody else, but I think at this point, we need to move it along.
Sure.
Just for the purposes of.
I just want to say 2 seconds worth of something.
Variance forms.
The board here is very thorough. Mr. Coffin, Greenbaum, everybody's very thorough here. And when I speak, when I first got it approved, I just spoke with the words from my heart. Everything I said is true, and it's all facts. You guys gave an approval on factual stuff, and you already approved it. So nothing has changed. Everything I said before, I'm saying over again, it's all fact. It's not hearsay. It's not made up. It's all facts. So the facts of the case hasn't changed.
Well, the only fact that did change is that you didn't do what you were supposed to do.
The only facts that changed is I wasn't aware of a 2-year statute, and at the same time, way before the 2 years was up, I gave Lavelle the go-ahead. I signed a contract with him. I gave him $1,800. It took him a year to do the work, and
Well, we're ready to vote.
yeah, so that's what thank you very much.
Thank you. All right, kids and cats, ready? This is for a petition for variance for Article 1044 to allow a 3rd apartment in the rural residential, 19-page road, R22, lot 32.
What were those 2 again? I'm sorry.
R22 is the map number.
Yeah.
Lot 32.
Okay.
After reviewing the petition and after hearing all the evidence, and by taking into consideration the personal knowledge of the property in question, Kingston Board of Adjustment has determined the following. 1, will there be a diminution in value of surrounding properties as a result of granting this variance? 2, will the granting of this variance be of benefit to the public interest? 3, will literal enforcement of the zoning ordinance result in an unnecessary hardship? 4, will substantial justice be done if this variance is granted? And 5, will the use contemplated by the petitioner as a result of obtaining this variance be contrary to the spirit of the ordinance? Sign like a lawyer or a doctor. Okay. Number 1, will there be a diminution in value? All 5 voted no, so there will be no diminution in value, so our number 1 passes. Number 2, will it be of benefit to public interest? There's 4 yeses, 1 no, so Article 2 passes. Number 2. Not Article 2, that's the wrong meeting. Yeah, to the end. Let's see, will literal enforcement result in unnecessary hardship? 4 voted yes and 1 voted no, so that 2 passes. Number 4, will substantial justice be done if this is granted? All 5 voted yes, so that also passes. And the 5th one, will the use contemplated be contrary to the spirit of the ordinance? All 5 voted no, so that it all passed.
Thank you.
Well, you could have made it shorter.
Listen, I'm so numb, I don't even know what that means. You want?
Okay, boys and girls, we have a decision to make here. Do I have a motion?
Yes, based on the criteria,
All 5 passing.
all 5 passing. Do you need be more specific? Okay.
No.
I vote that I propose that we
Grant the variance
Thank you.
to allow a 3rd apartment in a 2-family rural residential zone. That's what we're making the 3rd apartment legal, not a 4th. Correct.
Wait, time out. We're not making the existing 3rd apartment legal.
No, we're making it legal for him to have a 3rd apartment.
And that we both state that afterwards in the same criteria.
You're gonna have something else to say.
Yeah.
But the motion is to grant the variance for relief to allow a 3rd apartment in a 2-family residential zone. Okay, so the discussion, second, discussion. All those in favor, please say aye.
Aye.
Motion carries unanimously.
Thank you very much.
Sit, you're not done yet. You're not done. Be patient.
May I add something?
Yes, sir. You can kiss her all you want.
She's my best friend, not only my attorney.
You are aware you have to go to the planning board.
Yes.
You have to be in compliance with all the requirements of the building inspector
Yes, sir.
and the other inspectors, plumbing, both,
Yes, sir.
and fire department.
Yes, sir.
And town regs. And town regs, like there's a minimum
Yeah.
apartment size.
Yes.
So, just so you know all these things have to be done. They're not part of the
I'm fully aware of that.
motion.
But it will be the letter of approval.
Gotten to
You're gonna get a letter of approval from me that states that you will go to the planning board, get all the appropriate permits and licenses and approval and inspection by the fire
That's the plan.
department. Okay, that's all gonna be conditional. It has to all be
They're
done.
not conditional
Not
on this.
conditional. You have to do this. This is,
Of course.
This is the only
it's
way.
not an of course, because it hasn't been done in that house for a long time.
It will be.
Okay, and in fairness to our building inspector, the building inspector may not sit at the table and vote, but we do consider his and or her opinion. If it were her, it has a lot of bearing on what happens in here. That letter last November was read into the record. So maybe you didn't know about it, but it was in the record and you got a copy. So I want you to understand that we're not trying to just ram through things here. We try to.
No, I know that.
But you make inferences or assumptions because you didn't see it or you couldn't find it,
I
and
know,
that's not
I
always
know
the
Trish was
case.
saying stuff about the building inspector was against it. When I speak to him, I have him pulling permits.
Tell you the rules.
Yeah.
Has to uphold the regs.
When I
But
just.
I don't want to argue with you. I don't want to.
He's getting compliments with the property from the neighbors and with some of the Kingston residents.
Okay,
I'm
because
sure he is, but he can't ignore the illegal things that happen in there.
We have until February 12th, 2022.
It better be done, because if we see you here, back here, then you'll never get it.
I want the rent.
I want to be here.
Thank you.
Thank
Want to see that property.
I appreciate it.
Mr. Khalil, you did the agile. All right, do we have any?
Move adjourned.
we- No, it's not my job. It's not my job. I'm not gonna,